Good day everyone, I am Marizze Bueno from BSBA HRN 3103 and today I will present to you the continuation of the previous discussion as well as the grievance machinery and voluntary arbitration. So let's begin. Where there is no agreement between the parties as to the date of effectively, in case of an arbitral award made beyond the 6-month period by the NLRC in a certified case, the NLRC has the authority to give the CBA a prospective effect, or by the DOLE Secretary in a case of assumption of jurisdiction. The Secretary may make the award retroactive, since the law does not restrict the effectively of arbitral award by the Secretary. In the case of Mindanao Terminal and Brokerage Service versus Confessor, the Supreme Court made a similar ruling. In the absence of any specific provision of law prohibiting retroactivity of the effectivity of the arbitral award of the Secretary, he is invested with plenary and discretionary power to determine the effectivity thereof. This is the prevailing rule and the reasonable one, although in a latter case, the court held that in the absence of agreement between the parties, the award shall retroact to the first day after the 6-month period following the expiration of the last day of the CBA. The latter ruling was made pro hac vecie, or for this occasion only, in view of the peculiar circumstances of this case. It will be recalled that free collective bargaining and negotiations, along with voluntary arbitration, conciliation, and mediation, are promoted as a matter of policy provided in Article 218A as preferred modes of labor dispute settlement. Because an injunction contradicts this policy, Article 266 provides that no temporary or permanent injunction or restraining order in any case involving or growing out of labor disputes shall be issued by any court or other agency, except as otherwise provided in Article 225, which is the powers of the NLRC, and 278, assumptions or certification of a strike or lockout disputes. Article 273, Grievance Machinery and Voluntary Arbitration. The parties to a collective bargaining agreement shall include therein provisions that will ensure the mutual observance of its terms and conditions. They shall establish a machinery for the adjustment and resolution of grievances arising from the interpretation or implementation of their collective bargaining agreement and those arising from the interpretation or enforcement of company personnel policies. All grievances submitted to the grievance machinery which are not settled within 7 calendar days from the date of its submission shall automatically be referred to voluntary arbitration prescribed in the collective bargaining agreement. For this purpose, parties to a collective bargaining agreement shall name and designate in advance a voluntary arbitrator or panel of voluntary arbitrators, or include in the agreement a procedure for the selection of such voluntary arbitrator or panel of voluntary arbitrators, preferably from the listing of qualified voluntary arbitrators duly accredited by the board. In case the parties fail to select a voluntary arbitrator or panel of voluntary arbitrators, the board shall designate the voluntary arbitrator or panel of voluntary arbitrators as may be necessary, pursuant to the selection procedure agreed upon in the collective bargaining agreement, which shall act with the same force and effect as if the arbitrator or panel of arbitrators has been selected by the parties as described above. Article 274. Jurisdiction of voluntary arbitrators or panel of voluntary arbitrators. The voluntary arbitrator or panel of voluntary arbitrators shall have original and exclusive jurisdiction to hear and decide all unresolved grievances arising from the interpretation or implementation of the collective bargaining agreement and those arising from the interpretation or enforcement of company personnel policies, referred to in the immediately preceding article. Accordingly, violations of a collective bargaining agreement, except those which are gross in character, shall no longer be treated as unfair labor practice, and shall be resolved as grievances under the collective bargaining agreement. For purposes of this article, gross violations of collective bargaining agreement shall mean flagrant and/or malicious refusal to comply with the economic provisions of such agreement. The Commission, its regional offices, and the regional directors of the Department of Labor and Employment shall not entertain disputes, grievances, or matters under the exclusive and original jurisdiction of the voluntary arbitrator or panel of voluntary arbitrators, and shall immediately dispose and refer the same to the grievance machinery or voluntary arbitration provided in the collective bargaining agreement. Article 275. Jurisdiction over other labor disputes. The voluntary arbitrators or panel of voluntary arbitrators, upon agreement of the parties, shall also hear and decide all other labor disputes, including unfair labor practices and bargaining deadlocks. Article 276. Procedures. The voluntary arbitrator or panel of voluntary arbitrators shall have the power to hold hearings, receive evidences, and take whatever action is necessary to resolve the issue or issues subject of the dispute, including efforts to effect a voluntary settlement between the parties. All parties to the dispute shall be entitled to attend the arbitration proceedings. The attendance of any third party or the exclusion of any witness from the proceedings shall be determined by the voluntary arbitrator or panel of voluntary arbitrators. Hearings may be adjourned for cause or upon agreement by the parties. Unless the parties agree otherwise, it shall be mandatory for the voluntary arbitrator or panel of voluntary arbitrators to render an award or decision within 20 calendar days from the date of submission of the dispute to voluntary arbitration. Again, I'm Marizze Bueno, and that ends my report. Thank you.